You're watching The Attorneys, a paid advertisement brought to you by the law firm of Hollis, Wright.
Car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts with The Attorneys of Hollis Wright.
Hi there, thanks for joining us. Tonight we're talking about the type of case that may confuse a lot of people but affects millions of working Americans. You've done all the right things, you paid your benefits, you followed all the rules, and then when you need it most, your claim is denied. The question is, do you have a case? On The Attorneys, we're talking about ERISA claims. We're going to get into that in just a minute, but first we want to remind you that you can reach a lawyer at Hollis Wright right now. All you have to do is call 1-844-LAW-TALK, 1-844-LAW-TALK for a free confidential call. This is something a lot of people, Josh, really need to hear about.
I pride our firm and this show on trying to take sometimes complicated legal principles and put them into a user-friendly format that everyone understands. And this show is going to be a great example of that goal, what we're trying to do. David Martin is with us from the Martin Law Group in Tuscaloosa. He is an expert in this area and knows this area of the law. In fact, 15 or 20 years ago, I had my first ERISA case where I needed help, and I got David involved and have gotten him involved in some other cases over the years. So first of all, thank you for being on the show.
Good to be here.
We appreciate it.
Thank you.
How did this is a specialty area of the law. If you have a personal injury case and you need to litigate it, you come to me. ERISA is complicated. We go to experts like you. How did you get into this area of the law, and kind of how has this become a specialty of yours?
Okay, well, that's a real good question. I started out fresh out of law school as a general practitioner, and I did some personal injury and so forth. And after a few years, I noticed that there wasn't anybody that wanted to do ERISA. And I had an ERISA case. I resolved it successfully, and so I thought, well, let's take a look at this. So I started off with a health benefit claim. Company was refusing to pay for a baby that was born with this worker's wife's pregnancy, and so I thought, wow, that's really unfair. I helped with the case. It turned out fine, and anyway, I began to just go in that direction, just let my practice go in that direction. I have a little bit of a service-oriented attitude. I do want to make a difference on this planet, and so I saw a lot of unfairness, and so I thought, let's just do this. Let's go with it.
David is literally the state's go-to when someone has questions about it. It hits our listserv. Someone's like, "Hey, you need to call David Martin," and he'll answer your question for you. And in fact, the best part is prior to starting the show today, he said, "Just ask me anything about ERISA, and we'll figure it out." So that's good. That's good. So we're off script, right? All right. Someone asks you, hey, what is ERISA? How do we put that in a simple format?
Okay, well, first of all, it's an acronym, and there's a lot of federal statutes that are acronyms. And so it stands for Employee Retirement Income Security Act. And so that's the acronym. We just call it ERISA because that's quite a bit to get out every time you refer to the statute. It refers to the benefits that private employers provide to their employees. So if the employer decides I want to provide health insurance for my employees, that falls under ERISA as long as it's a private employer.
Gotcha.
If the employer is the government, there's a different statute, FEHBA, F-E-H-B-A, another
good acronym.
Like that. That applies for federal employees generally. Churches are exempt from ERISA, so church ministry organizations can opt in or opt out depending on what they want to do. So most of the time, if it comes from a private employer, it's probably ERISA, as long as the employer endorsed the plan. That's health, that's life insurance benefits, that's any type of retirement or pension benefit, that's disability benefits, really just about anything that can pop up in the employment context is going to be ERISA.
I've kind of looked at ERISA as a business owner myself and managing our law firm as long as I have with the benefits that we have. ERISA kind of sets the guardrails that if you're going to provide these benefits to employees, you have to do it in certain ways to make sure that people are treated fairly and to make sure that the benefits that are being provided are being distributed consistent with ERISA requirements. Is that a fair way to look at it?
Oh, yes, yes. Everything is governed by, well, first of all, the statute itself sets the minimum standards.
Yeah.
So you have to follow these fairness rules that are called a full and fair review. Yeah. So those aren't just words. They actually have a technical meaning.
Yeah.
A full and fair review means you're following the statute requirements as well as the regulation requirement under the claim procedure. So then the next thing that you look at is the plan document, and that's the insurance policy or whatever is being used for the plan document, and that's supposed to let everyone know these are the rules.
Yeah.
And so whenever somebody has an ERISA case, the first thing you do is you go look at your plan document, see what are the rules here. And so if the plan document falls below the standard, that's a problem.
Yeah.
The plan document has to meet the minimum standards, and then after that, you can have quite a few different things in there.
Good example of this is our law firm does not just govern these decisions internally. We have a lawyer that handles our ERISA compliance. We have an accounting firm that mandates and evaluates, for example, profit sharing, 401k, that we're doing it consistent with the requirements of ERISA and making sure that we're complying to make sure everyone is treated fairly, where we're not just overly compensating certain employees and not other employees. And we have rules that you have to follow on a yearly basis. I just did a 30-minute conference call about this 2 weeks ago, about making sure that we are within the safe harbor provision of our profit sharing plan so that we're being fair to all employees, not just highly compensated employees. And so this is a really complicated area of the law, but it's why you have guys like David involved. Talk with me about fiduciaries, because that seems to have changed over the last several years. Some of the brokers, for example, that wanted our business were trying to market to us that no longer does the firm have to be a fiduciary. They will be a fiduciary to manage the plan for us. I'm assuming that may either has changed or is just a way to reduce liability potentials.
Right. Yeah, that is something that can occur. So basically, when an employer offers a benefit, they're called a plan sponsor.
Yeah.
But if they don't name a plan administrator, then the employer is the plan administrator, and that's a fiduciary duty, okay?
Okay.
So if somebody else is delegated to be the plan administrator and operate the plan, they have taken on your fiduciary duties.
Gotcha.
So you can farm that out to somebody else. You're still the plan sponsor no matter what, but you're not operating the plan, so you're off the hook for the fiduciary duties. And so that's sort of what is occurring, is there's a delegation of that. A lot of times insurance companies will be the claim fiduciary. So there can be a plan fiduciary and there can be a claim fiduciary. The fiduciary duty is the highest duty known under the law.
Got it.
It's supposed to be something where you more or less have a power of attorney to act on behalf of someone, and you're supposed to do that in their best interests.
Right.
And that's where a lot of the unfairness pops up, is when they say, well, we're acting in the best interests of the whole plan, all the people, and not just this one person. And so sometimes
Makes
individuals
sense.
feel quite a bit of unfairness with the fiduciary actions that occur.
I know we're going to break. When we come back, Art, I want to talk with David about where he sees these issues come up the most, where there's litigation necessary, whether it's on the insurance companies not doing what they're supposed to, on the employers not doing what they're supposed to, and kind of what he sees from a litigation perspective, and how you go hire an attorney if you want something evaluated because you think you're being treated unfairly. We'll unwrap that too.
We will. And we told you at the beginning of this program that it was a complex situation, complex claims. However, you already know a little bit more than you did when you first started watching, and we're going to break it down even more so. Also want to remind you, if you want to get more information, some legal information out there, things you may not know about, go ahead and check out some of the Hollis Wright social media platforms on X, on Instagram, on Facebook. Great material posted there throughout the week. You can get that 24 hours a day. We're going to take a break. We'll be back as we're talking ERISA claims on The Attorneys.
Here's some good information from our firm to you. Hollis Wright recently launched the Law Talk podcast. With podcasts becoming so popular, this will be a simple way to provide our loyal viewers with more opportunities to access information about important legal topics and to learn more about our firm and how we can help you if the need ever arises. There are many ways to access the Law Talk podcast. You can simply scan the QR code on your screen. Also, episodes are always available on the Hollis Wright YouTube channel, as well as on Spotify, Apple Podcasts, or wherever you consume your podcasts. Just search up Hollis Wright in the Law Talk podcast. Don't wait, take advantage and listen today. Thanks for watching The Attorneys, and we know you'll enjoy the Law Talk podcast.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas such as bankruptcy, criminal law, civil law such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
Addiction kills hope.
But at Bradford, it all changes here.
Experience the difference
that proven treatment can make.
Find recovery, find community.
at Bradford.
You're watching The Attorneys, a paid advertisement brought to you by the law firm of Hollis Wright.
Welcome back. You're watching The Attorneys, and throughout the show you may notice at the bottom of your screen information scrolling there. We like to keep you updated throughout the show, not only what we're saying but also what we're putting out there, so you can see that as well. There's also a QR code. If you scan that QR code, that too will get you to an attorney at Hollis Wright. Welcome back to The Attorneys. We're talking about ERISA claims, and I know it's a lot to unpack. You set us up for this next segment.
Yeah, so let's talk just a little bit about what type of claims are you seeing that come in to you most commonly, and how are those handled from a lawyer's perspective and litigated?
Absolutely, sure. Well, 80% of everything coming into our office is long-term disability. And that's where somebody's disabled and the insurance company or the plan administrator is refusing to pay the claim. And so that is the bulk of what we handle. We also have some life insurance claims. And of course, that doesn't happen as often as people becoming disabled, fortunately. Mm-hmm. But nonetheless, we handle some life insurance claims that arise in the workplace. And then occasionally we handle medical benefit claims and pension and retirement claims. The long-term disability and the life insurance claims, generally we can handle on a contingency fee basis.
Okay.
We don't get paid unless we win the case. And so we handle 90% of those that way.
Okay.
Now we do represent some people who just want to pay us on an hourly fee basis, and we do help them too.
Yeah.
So we can do that. On the medical benefit claims, the money is getting paid to a medical provider most of the time, and so unless you are out of pocket a whole bunch of money already and you're suing to try to get your money back, well, there's no way for us to get paid in the scenario. So we generally have to handle those claims on an hourly fee basis, and we do have some of those.
Okay.
And then, of course, pension claims and retirement claims, there is a statute in ERISA that precludes a state lien from attaching. And so an attorney's fee agreement is a state lien in essence. It's a creature of state law, so ERISA preempts that. There's an anti-lien statute, so you can't take a contingent fee on those cases generally.
Okay.
And so you have to represent the people on an hourly fee basis. So of course, they got to do a cost-benefit analysis. How much do I want to pay this
that's
attorney
right.
to help me? Is there enough at stake to make that worthwhile?
Give us an example of a long-term benefit case where you can take it on contingency that comes in your office. Kind of walk through the process of what type of problem is the person having and how do you evaluate that case to determine whether or not it's a viable case?
Sure. Well, right out of the gate, we want to look at why was the claim denied. We want to look at those reasons. So they bring their letter terminating the benefit or denying the benefit to us, and we look at it, and generally there's just certain reasons why a claim is denied. As far as long-term disability. So it's you don't meet the definition of disability, whether that's your regular occupation or any occupation. There can be either one there. And then another basis would be you failed to provide proof of loss. And sometimes that's a generic thing where it's not really accurate. You did send in your medical records and you did send in a doctor's statement, but nonetheless, they'll say that. And a lot of times people do fail to send in enough evidence to the insurance company, and so they did fail to meet their proof of loss requirements. There can be a pre-existing condition situation. For example, if somebody has a headache 3 months before they become covered by a disability policy at work, did they get treatment for that headache? And then what is the disabling problem? You know, if they have brain cancer and that disables them, and it disables them within the first year, well, the insurance company may be saying, well, that headache was caused by brain cancer and that's a pre-existing condition. We're not going to cover you. Okay, so you have some debates with that as to whether that was just a migraine or just a normal headache or whether that was caused by the brain cancer. So those are the issues that we see on that. And then another reason denying a claim can be you met a limitation in the policy. For example, if you have a mental disorder of some sort, whether it's bipolar or anxiety, depression, a lot of times the plans or the policies will limit benefits to 1 or 2 years. And so when that occurs, you may max out on that. So then you have to look at, was that really a mental disorder or was there a physical problem causing that?
Right.
A lot of people we see, they develop depression and anxiety because they can't work. Work is good for the soul. People want to work. And when they become disabled, it's very disheartening and it causes depression and anxiety. How am I going to survive? What am I going to do? And so then they develop that, and the insurance company may latch onto that to deny the claim. So we have to fight that.
David's outlining why you have to get a lawyer involved in these cases, and you do not want to walk this plank alone. Just someone who's done this consistently and can say, and lead, guide, and direct you through the process, honestly, and say, here are the things that you need to look at, and can take the case on a contingency fee.
And as I listen to David, I'm wondering about future benefits. Are those benefits that can be recovered in a lawsuit?
That's a really good question. Sometimes when people come to us, there's only 2 or 3 months in past due benefits, and we can't take the case on a contingency fee then limited to the past due benefits, or we would be working for $1 an hour real fast. So you have to have enough at stake. So sometimes we will represent people into the future, and you can put enough benefits into that equation where then you can represent them on a contingency fee basis. You just have to continue to represent them maybe for 10 years in order to have enough at stake. Well, the fact remains that when you file a claim, you have your claim denied, you need an attorney at that point, even before it's time to file a lawsuit, because you have to make your claim record strong. If you don't have a strong claim record, you don't have a lawsuit. So the attorney has to help you filling that claim record with good information. Then when you file the lawsuit, all the court wants to look at is going to be the claim record in most instances. What did the insurance company have in front of them? And so the attorney, before it's time to file a lawsuit, needs to get that good information in there. Then when you file a lawsuit, the judge is only going to be able to award past benefits. You can't get future benefits, only past benefits. So you get a modest recovery in your lawsuit, but you saved your lifeline to future benefits. Because what happens is the court then remands the case after you win, remands the case back to the insurance company, and you're on claim again. And you can fight that fight repeatedly. I have filed a lawsuit 2 times on the same client against the same insurance company for the same claim. Filed it once, got a recovery, goes back on claim, 5 months later, denied again, I appeal again. And so a lot of times when we represent people over a number of years, it might not look like a great deal for the attorney because you continue working as long as the insurance company continued to deny the claim. But that's a service. That's part of the risk.
There are some procedural hurdles in filing these cases, and I want to talk a little bit about interest for back benefits that were not paid when we come back. And I know we're going to commercial right now, but just explaining the process and the requirements of why you get to a lawyer quickly in these cases, I think will be helpful.
Why you get to a lawyer and why you watch the show, because you get good information just like that. And all you have to do is be here for us. Also, you can get information by calling 1-844-LAW-TALK. Some information you need to know from an attorney, someone from Hollis, Wright, standing by. They'll take that call. It's free, and it's just between the two of you. That's a call you can make right now. We're going to continue this conversation. When we come back, you're watching The Attorneys.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon.
If this place could talk, it wouldn't. It would sing and celebrate all of our stories of addiction recovery, victory, and community. This is Bradford Health Services. It all changes here.
You're watching The Attorneys, a paid advertisement brought to you by the law firm of Hollis Wright.
And welcome back. You've been watching The Attorneys, and if you've been at home listening to this program, I know the question you want to ask. I'm going to go ahead and ask this question. David, how do you file these claims, a situation like this? How do you file a lawsuit?
Sure. Well, the plan document, first of all, requires you to file the claim in the way designated by the claim process. So even before you file the lawsuit, you have to make sure you have exhausted your claim remedies in the plan document, meaning there has to be a denied claim, then you have to appeal it and ask for a review. There could be a second appeal. So you have to go through that process first, and then it's ripe for litigation. Then you can file a lawsuit. If you jump the gun and file the lawsuit right away, your case will get dismissed for failure to exhaust claim remedies. So when you file the lawsuit, generally you want to file it in federal court. You can file it in state court, but a state court judge can only award benefits. So if there's other claims, like you need some equitable relief, or there's a penalty claim in the mix, those a state court judge doesn't have the power to award. So it's best usually just to go ahead and file it in federal court. And then, of course, once you file it, then you go through the normal federal court procedures, gearing up the case. The judge generally wants to know what's the standard of review on the case. Is there a fight about that? And if we can show that the claim process was abused or they didn't make a timely decision on review, then we will argue for a de novo review, which means the judge decides the case because the insurance company abdicated on its duty. And if it's arbitrary and capricious and the plan document reserves that discretion, then the judge is going to look at the insurance company's decision and decide whether that decision is wrong. And then to boil the 6-step process down, excuse me, the judge will decide whether that decision, even if wrong, has a reasonable basis to it. Because you have to show that they're arbitrary, which means there's no logic or rational reasoning behind your decision, and capricious, which means there's evil intent, like you are honoring your conflict of interest.
Yeah.
You know, you're paying the benefit out of your own pocket, so you are wanting to keep your money in your pocket rather than pay the claim.
Yeah, and I was going to ask that, like, why do these insurance companies, I mean, someone pays for long-term disability benefits, and the employer oftentimes is helping supplement that or paying for the employee. Why do these companies, when they are able to really amortize all of the money coming in over many policies, why are they incentivized at times to not grant benefits? Is it that they're looking for reasons to not pay a claim, and if they find anything, they're going to challenge that until it's legally challenged in reverse? I mean, where does this work its way out?
Well, unfortunately, a lot of times people experience a lot of unfairness and it doesn't work its way out.
Yeah.
It's just tough. So if a judge thinks, yes, this insurance company's decision is wrong, but you know, they hired this peer reviewer over here who disagreed with 3 different treating doctors who said, yes, this person is disabled, well, that's a reasonable basis. And so that's where you run into problems is, will the court actually look hard at the evidence, or is it just going to be a stamp?
Yeah.
You know, it's okay.
Talk for a minute about interest, because I know interest is a big component of insurance companies that are doing it the wrong way. Insurance can be a very important sword in these cases.
Okay, yeah, well, basically the insurance company, when it's paying the claim out of its own pocket, has a conflict of interest.
Yeah.
And that's supposed to be taken into account by the court. A lot of times the insurance company says, well, we wall off those people, the financial unit's over here, and the claims adjudicators, they're over here, and they're not sharing information, they're just doing their job. But statistically, you can show that some insurance companies have had a dramatic refusal to pay claim rate, more or less, and it has skyrocketed. Some insurance companies are just going to deny the claim no matter what you do. So that's when your focus is. Make the claim record strong so you have a chance in court.
Can you get up to 1% interest per annum, or 1% interest per month for benefits?
If you have a favorable decision, then the court can award interest to make you whole.
Gotcha. So it's a reason and incentive why people would get involved. And here's the deal. If you've got a claim like this, go to someone like David. If you forget David, come to us. We'll get you to David, because you need to have someone lead, guide, and direct you through the process. Great job, by the way, coming on and explaining a tough topic and a difficult, complicated topic in simple form. Thank you.
All right, David, thank you. Josh, thank you. Thank you for watching, and make sure you tune in again next week, same place, same time.
Thanks for watching The Attorneys, sponsored by Hollis Wright.